In this video, we're going to talk about the 6 things you need to know if you're arrested for a domestic violence offense in Arizona. 1. When the police get called out for a domestic violence incident, there's statutes require that they make specific determinations about the safety of the victim. And based on that, if they believe there's a potential risk to the victim, they might have to arrest one or both parties depending on the situation, right? So there are provisions where they have the discretion to release you, to just cite and release you like a paper arrest on minor misdemeanor issues. But for the most part, they err on the side of caution, and then somebody's going to get arrested. In the cases where there's use of physical force or use of an actual weapon, they have to arrest you. So generally, if somebody says you committed a domestic violence offense, like right then and there and called 911, you're probably going to get arrested and going to go to jail. So what's going to happen? When they take you down to jail, they'll process you in, they'll take your stuff, they'll change you into the jail uniform, whatever. But after your intake, that takes a little while, you're going to sit down and wait to see a judge. This judge is going to do your initial appearance, and the judge is going to determine your conditions of release. What are conditions of release? So the conditions of release are those things that you have to do or not do in order to ensure that the courts will allow you to have pretrial release. That means to stay outside of jail, not be incarcerated pending determination either of a trial, a plea, or a resolution or dismissal of your case, right? Basically, wait to resolve your case in jail or outside of jail. That's basically what that means, right? So there's different types of conditions of release that a judge may require. A common one is a bond. In the case of a domestic violence arrest, the most crucial, most important one of your conditions of release is a no contact order. It's an order to have no contact with the alleged victim. A no contact order on a condition of release is standard for any domestic violence arrest. So when you get released, they'll give you a document that provides you with all your conditions of release, everything you have to do or not do. Don't leave the state without permission, stuff like that. But the most important issue is that no contact. You need to look at it, see what it says, and make sure you understand it, because it can get you into a lot of trouble if you don't. 2, upon your release, you're going to have to find a place to stay away from the alleged victim. If you were arrested for domestic violence, it is very likely, if not certain, that the judge issued an order of no contact as a condition of release. So that means that you can't have contact with the victim, right? So you need to actually find a place away from this person. No contact orders are very broad. So usually that means no contact means absolutely no contact, whether direct, indirect, social media, nothing. No text messaging, no phone calls, nothing. And here's the hard part. If you live with the alleged victim, you cannot go back home. It doesn't matter that it's your home and not that other person's. It doesn't matter. There's an order from the court that says you cannot have contact with that person. So if that person is in your home, you cannot go home. You're gonna need to find another place to stay. So it's very important that you make sure you understand that no contact order, either directly or through a third party. So you can't even call a friend and say, hey, go tell her that I need my stuff or something. That's third party contact. It's also prohibited. Violating the no contact order can, at the very least, land you back in jail for a violation of your conditions of release. But it can even get worse. 3, this is a very important part that people don't understand. The only one who can violate the no contact order is you, the released party. The alleged victim is not bound by that order. So he or she can call you, text you, try and get in contact with you, can look for you, can forgive you, whatever. That person is not bound by the order, but you are. And just so we're clear, if you actually have contact with that person without the permission of the court, it's still a violation. Even if the alleged victim contacts you and tells you that he or she wants contact with you, having contact with that person is still a violation even if they want it. So do not have contact. If you get a call, do not respond. If you get a text message, you need to get the court involved. That person wants contact with you, he or she needs to contact the victim representative and make that known to the court. Do not, for any reason, violate the no contact order, because if you do, as you will see in this video, things can get a lot more complicated and a lot worse for you. 4, the only person who can modify or revoke no contact order is a judge. This is very important. It doesn't matter how many times the victim tells you that it's okay to speak with him or her, that he or she spoke to the judge and whatever. If you don't have a written order from the court modifying or canceling or allowing you some type of contact with the alleged victim, you are still bound by that order. I've had many clients who have been told by the victim, hey, no, I went to the court, I told them it was fine and we can have contact again. And that was not true. Be very, very careful careful. The only person who can do it is a judge. And just so you know, a judge does not have to agree with the alleged victim. The victim can actually go to the judge and say, no, I want contact with this person. The judge says, well, based on the allegations, I'm not going to allow it. I'm still going to tell him to not have contact with you. I've seen it many times. So make sure you do not want to violate that court order. 5, contact with the victim is both a violation of the conditions of release and a new crime. Yeah. So this is where it gets complicated and it gets dangerous for you if you are under a no contact order. So conditions of release, as I explained in the beginning of the video, is the things that you must do or avoid or refrain from doing in order to guarantee that you're going to be pretrial released, that you're going to wait for your trial for whatever disposition your case has, not incarcerated, right? So if you commit sufficient violations, the court doesn't feel comfortable with you being released, the judge can order you to stay in jail until the case is completed. That's a big no-no, right? Secondly, disobeying a lawful order of a court is a misdemeanor offense called interference with judicial proceedings. That's a class 1 misdemeanor. So if you violate the no contact order, your release can be revoked and you can be sent back to jail. In addition, they can file additional charges, at least one additional charge or several, depending on what happened, for interference with judicial proceedings, another class 1 misdemeanor. And then now you have another charge that you have to deal with while you're in jail. Oh, by the way, guess what? This type of interference with judicial proceedings can be classified as a domestic violence offense. Yes, if you violate the no contact order, your release can be revoked and sent back to jail, and you can get an additional crime, an initial misdemeanor charge that is also a domestic violence offense. So be very, very careful how you deal with these type of charges. 6, here's a practical example of what can happen to show you how fast things can get really, really bad. So let's assume a husband and wife get into a fight and the cops get called out and the husband goes to jail. He gets taken to jail, he gets processed, released, no major issues, but there is a no contact order in place. So 1, he can't talk to his wife, and 2, he cannot go back home. So upon release, he picks up his phone, he texts his wife and says, honey, I'm okay. I'm sorry about last night. We'll talk later, blah, blah, blah. Done. That is a violation of the release order. That is a violation of his conditions of release, and it's a new class 1 misdemeanor domestic violence offense, interference with judicial proceedings. Later, the wife calls her husband to see how he is. He sees in the phone, he picks up and talks to her. No insults, no problem, but just have a conversation. Second violation. Well, guess what? This is your 3rd charge for domestic violence. And guess what? That is aggravated domestic violence. Mandatory jail time before you can qualify for probation. Class 5 felony. If there's another text message on another day or another phone call, or if he goes home to see his kids or whatever and see his wife, that's another charge, another felony. And guess what? No more probation. In this case, you got to do prison time. Probably 1, 2, 3.75 years. Things can get really, really bad, really, really fast if you don't pay attention to a no contact order. So if you or someone you care about is facing domestic violence charges and need to talk to somebody, in the description down below, you'll find my contact information. If you're not ready for that, that's okay. Here's a video on my YouTube channel. I go more in depth as to what domestic violence charges are and what the types of they are and what is exactly a domestic violence offense. So you can go watch that. And again, if after that you still have questions, feel free to give us a call. I can give you a free consultation and we can talk about your case and see if we're the right fit, okay? I'm here to help, and good luck with your case.